All right. Welcome, everybody. I'm attorney Justin Randall with Hooper Law Office, and our topic today is on common caregiver mistakes. So what we mean by that is a lot of times as someone gets closer to needing long-term care, skilled nursing, or assisted living, they just need more help as they get older. They'll start to have a loved one come into the home and provide assistance, whether that's actually medical assistance or just other daily activity assistance. And at that point, that person becomes a caregiver. And oftentimes they want to provide reimbursement for that time that that person is, helping them. So they often accidentally do things, though, that can create problems later on when they need assistance from Medicaid, potentially in a nursing home. That if they had avoided those mistakes going into that, it would have made that situation a lot easier of a transition where they wouldn't have potentially had a penalty that they created for Medicaid. But before I go into a lot of detail on that, just a couple quick things. At the end of this, you'll receive two things from us. You'll receive our top 10 caregiver mistakes handout that we have. And I'm going to talk about a lot of these today, sort of touch on each one as I go through. But it's a really good summary of things that you want to avoid doing that a lot of people do by mistake. And it's not intentionally, obviously. It's just they don't know what the rules around Medicaid are. But it's a really useful tool. And then we'll also receive a form from us where you can give us feedback. You can let us know if you'd like us to reach out to you to set up time to have an initial consultation. Our initial consultations are complimentary. So nobody pays us anything to come in and meet initially for that first meeting so that we can really get to know the situation. We schedule them for about 2 hours, give or take. They're scheduled for 2 hours, but sometimes they don't take the full 2 hours. Other times they take a little longer, depending on the conversations that are being had and how much information there's to go through. But it's set up for that period of time to, again, really get to know you and go through the situation and all of the information that you bring in. So we'll send those out to you. We won't reach out to you without you giving us permission to. So if you really want us to, that's important. To mark that you'd like us to reach out to you. And then our topic next week actually is on protecting loved ones from themselves. So when we're talking about somebody leaving assets to a loved one, their children, grandkids, just family, friends, whoever it is, there are times where that person has some concerns regarding potentially substance abuse, responsibility, just young. Youth is its own concern when it comes to dealing with finances sometimes. So how do we protect what you're leaving to those people from those people and their concerns so that it benefits them still? And so that's a really common topic that we talk with about to our clients about their kids or their loved ones, making sure that that's going to them in a protected manner. And then last thing, this is interactive. So if you have any questions come up, if you are a caregiver or you're thinking about, starting to pay a loved one to provide care for you at home, and you have questions on that, you'll be able to submit them through the Q&A function, and I can see them pop up and I'll answer them as we go along. But okay, so common caregiver mistakes. There are a couple really big ones that people very commonly commit those mistakes or commit those errors when they're looking to have a loved one provide care. First and foremost, I would say as a caregiver, one of the biggest mistakes that somebody can commit is if they don't seek help when they need it. So I don't mean that you're not providing help to your loved one when they need it. Oftentimes somebody is providing that help as soon as they can because they're trying to prevent more expensive care being needed sooner, right? Trying to keep a loved one out of a skilled nursing facility for longer, or, not have to have the nurse come into the home and caregiver come into the home that outside of the family for longer. So to try to save money. But one of the things that can often happen with that caregiver is they start to wear themselves down because it's too much for any one person to deal with for some people, right? It depends on the healthcare needs of the loved one. It depends on the types of activities they need and how many hours per week they are doing it, right? It's going to be situational. But you want to make sure as a caregiver that you're not causing yourself any harm by not getting that assistance when you need it. It's very honorable to try to save money for your loved one as long as you can and help them out that way. But if you need assistance, it's better for your loved one to also acknowledge that and get that assistance rather than try to do it all yourself. So sometimes it works out where there's not that much care that's needed at any given time, and maybe they don't need to hire some help for that, but it's also okay to acknowledge that you do. So this is less of a financial mistake or one that somebody would make, in regards to Medicaid, but more for the caregiver themselves. You really want to make sure that you have the care you need. And so where this comes up a lot is spouses. Spouses trying to provide care for their spouse, and not spend money down so that they're saving money for the estate or saving money for care later on. But a lot of times then that spouse ends up having health concerns because they're not taking good care of themselves. So it's really important to themselves. So it's important for them to acknowledge that if they need it. But also the same thing goes for a child too. And with that child, if they have other obligations, they have a job of their own, they're supporting a family, right? They need to find ways to make sure that they're taking care of that too. So it can, my biggest thing I can tell you on that is it's okay to acknowledge if you need assistance with it. It's okay to also try to do it on your own at first, as long as you are able to and you're not causing any problems for yourself. But acknowledge when you need the help, so that it's better for your loved one too if you acknowledge that when it's time to acknowledge it and not years later. So that's less, like I said, less of a financial mistake, less of a Medicaid mistake, and just more of a personal mistake that I think people make because they're trying to do the right thing but don't acknowledge that sometimes they need help with it. And we all need help with things when the time comes, right? We can't do everything on our own. So the number one financial mistake, though, that people will create is paying a loved one for care without what's called a notarized caregiver agreement, which has to be a written notarized agreement that is explaining why they're paying their loved one, how many hours a week that loved one is providing care, what the hourly rate is, right? All of those sorts of things, because otherwise, even if you're paying somebody out of pocket and they are actually providing a service for you, when it comes time that you potentially need Medicaid assistance, if those payments have occurred over the 5 years preceding that Medicaid application, you have to report it to them as a gift. Medicaid's exception to those payments being gift is if there's a notarized caregiver agreement. And so they can't be retroactively applied. You have to do it before those payments have started in order for it not to be a penalty or a divestment. So you can't go back if you've already been doing it, but you can at least stop that being a divestment going forward, assuming that agreement's in place. Any sort of handshake deals, saying, yes, I'll pay you this much, are not a good idea, because you're not going to be able to show that agreement to Medicaid when you file an application. It's also just risky too, because without something written, it's hard for anyone to look back at it later on, whether that's Medicaid or the family, to know what the hourly rate wages were, or whether those payments were fair, right? So it's important to do that. So paying loved ones for care, don't think those cash payments, under the table are going to avoid Medicaid's gaze. You have to report those gifts and payments under penalty of fraud. So it's not something like Medicaid just won't find out about it if you have been making those payments without that caregiver agreement and it's just been in cash under the table and there's no record of it. One, they're going to look at your bank statement. So if they see regular withdrawals of the same amount, they're going to assume that you were taking it out and gifting it away if you can't explain. And two, that penalty of fraud is not something you want to incur, right? You don't want to commit fraud just to avoid creating a Medicaid penalty. It's important to make sure that you're upfront and honest with it. It's better for you, for your loved one. And I can guarantee you an attorney would not, if they knew about those payments, would not file a Medicaid application for somebody and commit that fraud. So it's just really important to be honest about it. So don't think you're getting around it either, though. That is one of the most common questions we get is, well, what if we just don't tell Medicaid about it? Well, we have to. So it's important to make sure that that agreement is written and in place and properly executed, so that you can look back and keep records of things. After that agreement's in place, it's also really important to keep running tab of how many hours of labor work provided, when those payments occurred, how much was given out at any given time, right? So just because that agreement's in place doesn't mean your work's done. You still need to keep an accounting of everything too. It can just save you the hassle later on of trying to look back and, show from the bank statements that, yes, this was a payment at my hourly rate for X number of hours, right? You need to keep track of those hours. You need to keep track of those payments, even after that agreement is in place. In regards to those caregiver agreements, they have to be, they cannot be lump sum payments either. So you have to do it as like an hourly rate stretched out over time, right? It can't be like all upfront payments. It can't be in advance. It can't be all a lump sum at the end. You want to keep track of it over time. So no lump sum payments for those caregiver agreements. So one of the, I've sort of already mentioned the handshake deal issue, but across the board when it comes to legal planning, handshake deals are a terrible idea. Always have agreements in writing. But with caregiver agreements, the issue there is even if those payments are legitimately for care that that person has been provided by a loved one, you have no way of proving to Medicaid that that's what that was for, right? They're not going to take your word for it on an application. I always tell people that Medicaid is sort of the opposite of the way that like our criminal justice system works, right? Or rather is supposed to work, where it's you're innocent until proven guilty. Medicaid reverses that, and they assume that if you can't explain where that payment went, that you were making a gift, you were making a divestment. So don't think that you're going to somehow be able to explain that later. That's why you can't do it retroactively either. It's really important to do it in advance. So if you're thinking about doing that, thinking about having any sort of caregiver agreement put in place, make sure that you have discussed this with an elder law attorney before those payments have begun. Again, if you've already started receiving payments and you don't have this agreement in place, make sure you sort of stop the bleeding or stop the penalty from accruing and just get it in place. You can't really fix it going back unless you return all those payments, but it's important to put in place. So some other problems with caregiver agreements though, once they're in place, like I said, keeping track of things is really important. Keeping accountings is important, but the caregiver receiving those payments has to make sure that they are filing those on their income taxes. It's taxable income, their wages. So you don't want to not create a Medicaid problem, but then have tax fraud committed either. You have to report it as taxable income. And I know most people don't want to pay taxes or want to pay as low of taxes as they possibly can. I understand that inclination, but in this case, you have to report it as a taxable income. But why that's important to receive these payments too, yes, it's taxable income. So when people find that out, sometimes they're concerned as well, then what if I just don't get paid, right? What if I get reimbursed in a different manner instead of those payments, so I don't have to pay tax on it? I understand not wanting to pay taxes on it, but one, if you have to quit your job to provide care for a loved one or take fewer hours at work, you should receive fair compensation for that, right? It's okay to take wages for that. And you're helping your parent still or your loved one still by doing that. So there's nothing wrong with taking those as taxable wages. But when people try to get around the taxation of it and find other ways to get paid, they still run into issues. A very common thing would be that the parent starts to buy the groceries for the caregiver, right? Or for their child who is the caregiver, saying, this is my form of payment. Well, again, without that notarized caregiver agreement, one, that's a problem. Two, they will look at that as a gift as well, because it's not a direct payment to the caregiver. It's a gift. You're buying someone else's groceries for them. With caregivers, speaking of groceries, a very common mistake that they make is they go out and buy groceries using their own credit cards, their own debit cards, cash, whatever, and then their loved ones will reimburse them later with cash. That's a problem too, just because then you have to be able to show that that went for a reimbursement of something, right? And that's very difficult to keep track of. If you're a caregiver, if you have the power of attorney for that parent or loved one that you're taking care of, make sure that you use their debit cards, their credit cards to buy groceries, right? Make sure you're using their assets to do so for them, not for yourself, but for them, so that you don't have to go through that reimbursement. You're just making sure that it's coming out of their accounts. When it comes to spouses providing care, one of the most common things that people try to do to avoid having assets be available or for Medicaid later on, or having it, receive compensation for what they're doing, is a spouse paying a spouse to provide care, thinking that it'll shift the assets over to the healthy spouse's name, be out of the spouse who's going to need care's name, and then not reportable to Medicaid. Well, when it comes to Medicaid, it doesn't matter whether a bank account is in the name of the healthy spouse. It doesn't matter whether it's in the name of both spouses or the name of the sick spouse, right, or the spouse who needs care. Those types of assets, those cash assets like that, are still going to be counted as available assets for Medicaid. The only assets that are not available for Medicaid are the primary residence if one of the spouses is healthy and still living in it, and the healthy spouse's IRAs or 401ks. Those are exempt from the other spouse's care. A life insurance policy of not more than $1,500, or across all policies of $1,500 total face value, and a vehicle, and then depending on the assets that they otherwise have, anywhere between $50,000 and a maximum of about $137,000 of other assets outside of those things. So by shifting assets over to the other spouse, you're not helping that calculation most of the time. You can't just shift one person's bank account to the other and it suddenly not be available just because it's in the healthy spouse's name. So that is a big mistake, mostly because you're not really helping anything. It's giving you that false sense of security without actually doing any protection. Making that spousal payment is not going to be helpful. There's other planning that you can do if that's what you need to do. If you're paying a child for care, making sure that they have that caregiver agreement in place is essential. Making sure that they are filing those income or that as an income tax, paying the income tax on that is important too. Now, when it comes to trying to avoid those tax situations for the child, I talked about it a little bit for the spouse, but for the child, that's, the groceries is one component, but sometimes people also talk about, well, what if I buy a gift for you? Or what if I transfer the home into your name as the child, and that's my way of paying you? The problem with that is one, buying gifts for someone is still a gift. So that's still a divestment for Medicaid. It doesn't matter whether it's as compensation or not. It has to be through that caregiver agreement that you're making payments. It can't be these gifts, these lump sum gifts, or even buying a gift and then gifting it to them, right? That can be an issue. So it's really important to just, if you're going to pay that child, pay them through that caregiver agreement. When it comes to gifting the home or putting the home in the child's name, who's the caregiver, this can create a lot of issues as well, just because that is also a divestment, unless it is under very narrow exceptions. The caregiver child exemption of transferring the home, so where a parent can transfer the home to a caregiving child and not have it be a penalty or create a penalty for them. The child has to have been living in the home within or in the 2 years immediately preceding that loved one's admission to an institution. And so this is also only really used when somebody has actual skilled nursing care, because that's where institution comes in terms of institutionalized under Medicaid's definition. So if the child wasn't living there for 2 full years immediately before, you can't do like 1 year, a gap, and another year. It has to be 2 full years immediately before that institutionalization. Then you're not going to meet this exception. You also have to have a notarized statement, either by a physician or somebody who has intimate knowledge of the situation other than that child or other than a child, that says, yes, they were providing care for them. They were keeping them out of a nursing home. They were providing this assistance. I would always recommend getting it from a physician as opposed to anyone else, just because there's going to have more weight there of the physician saying, hey, they absolutely did provide care. They helped keep them out of a nursing home longer because they didn't need that care from someone else, right? But unless you have those exceptions where you have that statement, you have the immediate 2 years prior to that institutionalization, and if it's otherwise at home care or potentially assisted living or something like that, you're not going to meet those exceptions either. So it's really important to not think you're getting around that just through that payment. always talk to someone who's an elder law attorney first before you think you're getting any sort of exception to a divestment. When we have people come in and talk to us, if they have been living with their parents for a number of years, they've met that 2 years, the loved one is about to go into a skilled nursing facility, right? When you're able to get that notarized statement, that's something we would advise our clients on as an option. But if you're not being advised that that's an option, don't assume that it is. Don't read something on the internet and think you qualify, because one, as we all know by now, the internet is a dangerous place sometimes to rely on what's said on it. And two, without the background knowledge of the rules and all of that, it's hard to know sometimes whether it actually applies to your situation. So always talk to somebody who has experience dealing with Medicaid and elder law planning, specifically an attorney who can help you figure that out. Transferring the home over is not a good idea for that, to try to meet that exception. It's not going to be counted as payment, it'll be counted as a divestment. And partially too, that's because most of the time the payment, that person has accrued over time, or what that value of their services were, most of the time does not even get anywhere close to the actual value of a home. Sometimes it does, I suppose, but not generally. But even then, without that, being a purchase of the home, it will be a divestment. So one very common thing outside of that is when someone promises to leave maybe an extra percentage of the estate to that loved one who's provided care as reimbursement for the care they've provided, or maybe just add them in as a percentage of the estate. If it wasn't a child who was already receiving something, maybe they'll say, well, I'll give them this X percentage of my estate as sort of a thank you. They earned it, and because it may not be taxable to them. And it's true that wouldn't be a divestment to add that person on as a percentage beneficiary of the estate, because you're not actually gifting it until you pass away. But where the issue comes in is when we're talking about someone potentially needing long-term care. Yeah, you may be able to leave them a percentage of the estate, and that's your goal behind that is as payment or reimbursement for what they provided to you during lifetime. But in order to qualify for Medicaid, so if you end up needing Medicaid assistance in a facility, there's asset limitations on that, right? So for a single person, for the most part, you're going to be able to keep the home with a lien on it as care is provided. You can still have the life insurance of $1,500 total face value, and a car and $2,000 in assets, right? So if you have to spend down to that to get Medicaid assistance, promising them a percentage of the estate when there may not be much of an estate or not an estate at all after you pass away because of Medicaid's asset limitations and their ability to recover against your estate, promising them a percentage of that is not really fair compensation. It's a nice thought. It's in theory, if somebody passed away without needing much Medicaid assistance, I suppose there would be value in the estate left because there wasn't much to recover, potentially, but it's not guaranteed by any stretch of the imagination. Very likely they're not going to receive fair compensation because there's not much to receive a percent of at that point. So it's, like I said, it's okay to pay these people, making it taxable income, paying it during lifetime rather than a way to receive it tax-free at the end of someone's life. Because if you have that notarized caregiver agreement, you're not creating a penalty for Medicaid, you're keeping track of everything. Yes, that person has to pay tax on it, but it is better for them to receive taxable compensation than no compensation at all, potentially, if that's your goal. Now, there are a lot of children out there who try to provide that compensation for free because they feel it's the right thing to do. I understand that, but it's also okay to pay a loved one too. So, promising percentages of the estate is never a good idea. So I mentioned a lot of things about payments outside of the caregiver agreement that can be an issue. Making sure, I mentioned groceries, but that goes for all sorts of expenses, by the way. Don't pay for their mortgage, don't pay for their utility bills, right? Don't pay for the kids' tuition. Don't do that as a reimbursement for care, because that is going to be a Medicaid divestment. Make sure all payments are coming through that caregiver agreement. Now, one thing I haven't mentioned is what you should do if you're concerned about losing capacity before you have a caregiver agreement in place. So it's not unheard of for, by the time someone needs that type of assistance from a loved one, that they may have cognitive decline due to Alzheimer's or dementia. If that's the situation, well, if the parent in that situation or the loved one in that situation doesn't have capacity to sign a notarized contract, and there's no other way to get it in place, well, there's going to be issues, right? You won't be able to get that caregiver agreement in place because they don't have capacity. So the solution to that is looking at the financial power of attorney that that person has and making sure it authorizes the power of attorney agent to enact a notarized caregiver agreement. Make sure it has that authority. A lot of times they don't, and that's not because of any intentional omission, but it's because a lot of times people's powers of attorneys are the state statutory forms where it's very bare bones, or it's drafted by an attorney who isn't drafting it with Medicaid planning in mind, and so it doesn't have the authorities that they would need in there. So all of our powers of attorney have the ability for that power of attorney agent to enact a caregiver agreement if it's necessary. My power of attorney has that in there for me because I'm the one who drafted it for myself. I'm nowhere near needing that, but it's in there. So it's really important to have that, especially if the concern is that at some point the loved one, has a diagnosis where they may start to lose capacity. I mean, when we have capacity concerns because of someone's diagnosis of Alzheimer's or dementia, our first recommendation is if they have capacity still to sign an updated power of attorney, it's essential that they get that in place. So if you are starting to provide care for a loved one and they're able to update powers of attorney, have it looked at, make sure that that has the authorities it needs to have, so that if they do end up losing capacity, you can do what you need to as a caregiver to put that agreement in place to, pay for their bills out of their own, accounts, things like that. And the sooner you do that, the better. I wouldn't expect you to be able to read through that necessarily, or someone who's not an attorney that does elder law planning to read through it and look at that and say yes or no, it has those authorities. So I would always recommend talking with someone who, is an elder law attorney specifically to look at whether that has the authorities it needs. Okay, so I'm not seeing any questions and we're running close on time here. So just a couple quick recap things for you. Our topic next week again is on protecting loved ones from themselves. So that protecting them, the inheritance that you're leaving them, protecting them from causing harm to themselves with that inheritance. It's going to be a really interesting discussion about, how to do that and the best ways to do it and concerns that people have. And then again, at the end of this, you'll receive our handout on the top 10 caregiver mistakes that people make as a kind of reminder of all the things we've talked about today. And I basically hit on all of these, but just as a reminder. And then also a feedback form where you can let us know if you'd like us to reach out to you to set aside time to have an initial consultation. And again, those are complimentary. They're set up for about 2 hours. And, we ask for a lot when you come in to talk to us, a lot of information, but that's to give us a really good idea of at that meeting of what we would recommend. So if you are a caregiver or you think you may need to be a caregiver soon and you don't have the powers of attorney in place, the caregiver agreements in place, and you need to get those in place, I would absolutely recommend coming in and talking to one of us about that. With that, I still don't see any questions. So I hope you guys have a good rest of your day and we will see you next week.